Hello everybody, you have tuned in to Eric Jose on Making a Murderer on YouTube. I cover virtually any aspect of making a murderer. I go over the evidence, the documents, the photos. So if you like, stay tuned, and in the future I'll have many more videos besides the one you're about to see. Hey, hello everybody, how you doing today? We are here today to talk about Brendan's team, their response to the state's, respondent brief. So basically, it's really good in my opinion. When I read this thing, it sounds like Brendan's team now is kind of going on the offensive. Like they're taking the argument right to the state at this point. And a couple points in here where I feel like that's particularly happening. I wanted to go ahead and say thank you to Tracy Struncy, who did a live video last night on Facebook that was very informative for anybody that hasn't got a chance to see it. I would suggest trying to go check that out. It's in her Facebook group called Basically a Lawyer, and she basically shared and cleared up a lot of things about what was going on, particularly today. Just so everybody understands, today is May 26th. As of today, there was an article yesterday on the 25th or the 24th stating that the appeals court had made a decision to accept to amend the record and accept this CD that was given to Kathleen Zellner, and that she is now trying to put in to amend the record so that she can talk about what's on this CD at appeal. And so this newspaper article had said that it was that the motion was granted, but it hasn't been yet. It's not yet. They don't have to make a decision until the 29th. So they technically, from right now on the 26th, they have 3 more days to decide it. As of right now, they haven't yet. They sealed the CD and everything so that a bunch of people couldn't see it while they are making their decision, I guess. Okay, so that's what that means. That newspaper article was unfortunately not correct. So I wanted to help her dispel that. And also just to explain the process of what's going with what happens here with Brendan. For those who may not know, the state he's at right now is the cert stage, and right now what he's trying to get is the Supreme Court just to accept his cert for certiorari, or his writ for certiorari. That's why they call it cert. That just gets his foot in the door so that the justices are actively looking at his case, and then he needs one more justice. He needs 5 justices to get to what they call the merit stage. And that's when they really begin to dig into the case, and that's when they call in the lawyers for oral arguments if they deem it necessary, and that sort of thing. So there's kind of stages. So if he gets cert, then that's great. Then he's got his foot in the door. Then it's a matter of one other judge, at least one other, a 5th judge, that will then look at it and go, you know what, I think there's something going on here, and he will vote for it to move on to the merit stage. And then that's when, like I said, it becomes, they start talking about it in earnest. It becomes a something that they're really, really digging into. And like I said, that's also when they will call in the lawyers for oral arguments and so on and so forth. So anyways, it was very informative. Anybody that hasn't got a chance to go check it out, I would suggest that you maybe go over and give it a look, because it's very interesting. She knows her stuff. She's gone to school, and she's put a lot of work in. She says basically a lawyer because she's just short. She's a couple classes short of what she would need to be able to go take the bar. So she spent a fair amount of time in school studying the law, and so and she follows it regularly. She watches the Supreme Court dockets, and she's able to decipher all these things. So she's no slouch. Anyways, moving on to this brief. What I like about this brief is, like I said at the beginning of the video, that it seems like Brendan's attorneys are now kind of getting a little bit more aggressive and going and taking the fight to the state here and pointing out some of the best part is the part where they start pointing out what the state decided they didn't want to talk about, what they avoided in their respondent brief, which I found is very interesting. I have to apologize if there's going to be a little bit of machine noise here today, folks. There's a re-roofing happening nearby here, so anyways, I do apologize if any of that bleeds into the background of this video. But anyways, to get on to what this brief is saying, it's basically talking about how the state has misrepresented Brendan's argument as to what he's arguing. The state, if you may remember too, the state in their respondent brief kept saying that Brendan was trying to change the law. That's specifically what Brendan's lawyers are not trying to do. That they're saying he's trying to rewrite the law to make the courts have to write longer opinions. No, not necessarily longer opinions, but they need to address the special care aspect that has been mandated by the Supreme Court in AEDPA cases, AEDPA. They're just saying that the special care has to be there. And if there's no evidence of special care in juvenile cases, how can we know that there was special care? And it's a valid point. So we'll move into the first screenshot now. Respondents' opposition rests largely on the same error made here by police, the Wisconsin courts, and the en banc 7th Circuit, disregarding the fundamental difference between interrogations of adults and interrogations of juveniles. In particular, respondent never acknowledges the critical fact that interrogation tactics that can produce a voluntary and reliable confession from an adult often overawe and overwhelm a juvenile, potentially inducing a coerced and false confession. No matter how sophisticated, a juvenile subject of police interrogation cannot be compared to an adult. That is why this court requires the special care, indeed the greatest care, to be used when assessing the voluntariness of a juvenile confession. It is also why the court has mandated that courts address a juvenile's voluntariness challenge and perform an actual evaluation of the juvenile's age and intelligence in determining whether the confession was coerced. Respondent never meaningfully addresses these mandates. He instead urges, consistent with the Wisconsin Court of Appeals decision, that the special care requires nothing extra at all. That is manifestly wrong. Now, a lot of the main things that Brendan's lawyers are bringing up in this brief is that, one, that the state, in citing the case law to support their arguments or whatever, is citing a bunch of cases that are really about adult interrogations, and they're not really addressing the fact that juveniles require special care and can't be evaluated in the same way that you evaluate adult confessions. Hence the need for special care, hence the need to talk about how the special care was instituted and exercised, really. So that's what they're getting at here, and the state has been kind of deliberately avoiding that. They've been, as I said, they're citing case law from cases that deal with mainly adult interrogations. So, I mean, the state is basically desperately avoiding certain aspects of Brendan's arguments here. In the future, moving forward, they are going to ensure that, juveniles get that special care, is what I hope. There needs to be something there so that because like what you've been seeing from the state of Wisconsin and even from the en banc, you get this feeling of, we don't really want to think about it. We don't want, with the state of Wisconsin, we know that they have an interest in keeping Brendan locked up because they're afraid it may weaken the whole case against Stephen Avery if he gets out. And they're desperate to keep Stephen Avery behind bars. But the en banc review, I'm not so sure. I think it's just some kind of dogmatic loyalty to following the AEDPA or something. It's really strange. But then again, they did cite the control question just like Tom Fassbender does, and misrepresented that in the same way that Tom Fassbender in the state does. So that's a little fishy with the en bancs, with the en banc majority anyway. So, but the thing is here, I think that the Supreme Court, in looking at what the law professors in their brief and stuff, and the things they were pointing out, the past decisions by the Supreme Court, and how they've so repeatedly stated that you have to be careful with juveniles. They are much more susceptible to psychological coercion or any coercion than an adult is, and they've said it multiple times, not just a handful, not just a couple times, but many times. So this is going to be, I think, where all this whole thing pivots around this argument about special care, what it is, and how it's going to be proven. I think that juveniles are receiving it in the future, because I think that these state courts are kind of having a cavalier attitude in applying special care. I think it's pretty obvious, and that's something else that Brendan's lawyers are pointing out here. Lastly, respondent asserts that AEDPA precludes the court from using this case to correct lower court's broader disregard of its precedent. That is wrong. This court has repeatedly granted review in AEDPA cases to give lower courts guidance. For example, the court gave guidance regarding claims of race discrimination in jury selection in Miller L. v. Dredke. And in a trio of AEDPA cases, this court instructed lower courts about how to apply the ineffective assistance of counsel standard. Wiggins even recognized that in providing such guidance, the court made no new law. In short, there is ample precedent for this court to use this AEDPA case to address the special care standard and the lower court's departures from it. And you know, that right there is exactly what I've been saying all along, kind of, is that the Supreme Court does need to, like, thump the lower courts across the country. They need to thump them and go, you know, look, you stop leaning on AEDPA adult standard when you're talking about juveniles. That, I mean, it just seems like a no-brainer. It needs to happen because you can't apply the same standard you apply to adults to juveniles. It's not good. Doesn't work. It's proven that using adult tactics, you know, particularly with the Reed technique, produce a greater number of false confessions in juveniles, particularly those with limitations or those who are so highly suggestible. This is proven, and the fact that the lower courts are resisting this is really what this case is all about. The lower courts are resisting this obvious knowledge. And this is why the Supreme Court needs to step in and give them a thumping. So now we're going to move to the last part, which is kind of my favorite bit that I picked out of there, where this is where Brendan's lawyer is going to pointing out everything that the state is avoiding, that they don't want to talk about, or that they're particularly sidestepping, or I mean deliberately sidestepping. So here we go, and we'll come on back one more time. Now, I do love this bit because this is where, you know, Seth Waxman and, you know, Brendan's legal team as a whole or whatever go after the state. They actually start going and pointing out everything that the state is deliberately not addressing in their argument. So this is good. Okay, second, respondent reprises his straw man claim that Dassey seeks to change the law in light of recent social science research. He's not seeking to change law. That's not what he's trying to do. That's a ridiculous statement on its face. As noted, however, the petition explicitly rejected this notion and explained why the research is relevant. The petition also explained that this court has repeatedly relied on similar empirical research in discussing closely related issues. Respondent notably offers no response. Respondent also attempts to resist the plain fact that Dassey's confession was essentially the entire case against him. Respondent cannot, of course, deny that no forensic or other direct evidence linked Dassey to the crimes. He instead dismisses that as unsurprising because Dassey and Avery had 4 additional days to clean it up. But as respondent knows, there was ample evidence left behind, just none linked to Dassey. For example, Avery's blood and DNA were found on items on the property, specifically in the victim's car and on her key. Respondent's theory is thus that Avery and Dassey conducted an absolute perfect cleanup of some items and areas, but did little or nothing elsewhere. That is utterly implausible. So yeah, that bit right there is highly valid. You know, I mean, there is no evidence against Brendan Dassey. And think about how silly it is that the state is contending that Brendan and Stephen cleaned it up so well that they got everything of Brendan, but not Stephen. I mean, there's still some of Stephen's blood. There's still some deer blood on the floor. You know, all this stuff. I mean, how is there not a trace of Brendan? How is, like, I mean, if they didn't clean up the deer blood, I mean, how is it like maybe not one of Brendan's hairs or something and, you know, fell on the deer blood or something? Would they have known on every spot in that garage which hair that they were looking at on the floor or something was Brendan's, or who was maybe, I don't know, some furry critter from around there, a bunny rabbit or something? How are they going to know what hairs or what's DNA is that they need to pick up and which DNA they don't? How would they know that? Right? Just looking at hairs on the ground or stuff like that. Or smudges, you know, from, I don't know, sweat smudges or whatever it might have been. How are you going to tell what it's from? Was it from today? Was it from another day? Was it from, you know, whatever? I mean, that's the whole thing. And plus the whole fact of the matter is that there is no trace of Brendan in the garage or in the trailer. There's no trace of Brendan. So literally the only thing that the state has against Brendan is this extremely wonky confession that is completely unbelievable. It's not. It doesn't look voluntary in any way. Yeah, the facts are all fed to Brendan. I mean, there's nothing about this confession that that leads you to go, okay, no, you know what? It's legitimate. I think he was really there. Everything tells you that the investigators are bullying this poor kid so that they can use it against Stephen Avery. And that's the sad part of it. And it's sad that the 16-year-old kid had to get thrown behind bars for such a stupid and silly reason. Because it's not fair. If you didn't have a case against Stephen Avery without Brendan, you should have left. That's the way it goes. You shouldn't have brought Brendan into this. I think, and I still maintain that it's going to be the biggest reason why you're going to lose your whole grip on Stephen Avery is because you went after Brendan in the first place. Brendan's going to be the thing that starts the dominoes to fall. Soon as people start to realize and more people start to take an interest in what happened and in juvenile justice and see what happened to Brendan, there's going to be a lot more support for Brendan eventually. Because this won't stand. People, I'll put it another way. My boss, who is a very staunch supporter of law enforcement, very staunch, he will generally always back law enforcement on anything. And for the last year and a half, 2 years, when I've been talking to him about the Stephen Avery and Brendan Dassey cases and stuff, he was always like, he naturally doesn't really have much sympathy for Stephen, because like I said, he tends to side with law enforcement almost automatically. But recently, he was watching the Dateline about the case with Stephen Avery and Brendan Dassey, and when it got to the point of talking to Tom Fassbender and seeing Tom Fassbender explaining the interrogation, and then he saw clips of the interrogation on that Dateline, he called me after it was over. He called me after the Dateline was over, and he said to me, "Okay, I believe that Brendan was coerced." He called me. He picked up the phone to call me to tell me that. That's how important it was to him to tell me that. And what was the main reason for it? The main reason why is because he was sitting there thinking about, what if that was my kid sitting in that interrogation room and these jackasses were doing that to my kid. That's essentially what flipped him on Brendan. And a lot more people are going to flip that way. A lot more people are going to see it just like that. Because like I said, if this guy, my boss, who is a staunch supporter of law enforcement, almost to the point where he almost thinks they can do no wrong, has flipped. He doesn't accept what happened to Brendan Dassey. So that to me is very meaningful. And I gotta imagine that it's going to be continuing to happen in the years to come. Regardless of what happens with SCOTUS, this issue is not going to go away. So that's about it for today, folks. I hope you enjoyed it. If you haven't already, please hit subscribe, and we'll see you.